If you are a landlord in England right now, there are 5 things you may still be doing that are completely and totally illegal today. And if you are a renter watching this video, these are the exact 5 illegal things your landlord absolutely cannot do to you anymore. The Renters' Rights Act 2025 came into full force on the 1st of May 2026, and it changed everything overnight for landlords across England. These are not small technical changes that barely affect anyone. These are massive fundamental shifts in what landlords can and cannot legally do right now. Every single one of these 5 illegal actions carries a financial penalty of up to £7,000 for a first breach right now. And for repeat or serious violations, that penalty rises to a staggering £40,000 or even an unlimited fine through criminal prosecution today. Local councils now have dramatically enhanced powers to investigate landlords, access their financial records, and issue these enormous fines without warning at all. The days of landlords quietly breaking the rules with absolutely no consequences are now permanently and completely over under the new Renters' Rights Act. Let us go through all 5 illegal things right now, starting with the one that has shocked the most landlords across the entire country. The first illegal thing your landlord cannot do anymore is serve you a Section 21 no-fault eviction notice under any circumstances whatsoever today. Section 21 no-fault evictions have been completely and permanently abolished across England as of the 1st of May 2026 with immediate effect for everyone. Any Section 21 notice served on or after the 1st of May 2026 is completely invalid and has absolutely no legal force or standing. If your landlord has handed you a Section 21 notice since the 1st of May 2026, they are breaking the law right now today. Your landlord can no longer remove you from your home without citing a specific and legally recognized ground under the new Section 8 process. They must prove that legal ground before a judge in court, and if they cannot prove it, you stay in your home completely protected. A landlord who uses Section 21 after the 1st of May 2026 faces a civil penalty of up to £7,000 from the local council. If you have received a Section 21 notice after that date, contact Shelter or Citizens Advice immediately, because that notice is completely and totally invalid now. Do not leave your home, do not pack your bags, do not hand back keys based on an illegal Section 21 notice ever. The second illegal thing your landlord cannot do is offer you a fixed-term tenancy or use a contract end date to remove you. Fixed-term tenancies have been completely abolished in England from the 1st of May 2026, and all existing tenancies automatically converted overnight to rolling tenancies. If your tenancy agreement says it ends on a specific date, that clause is completely void, and your landlord cannot enforce it against you. A landlord who tries to advertise or let a property using a fixed-term tenancy agreement now faces a civil penalty from the local council. Your landlord cannot stand at your door on the day your old contract expires and tell you that your time is up, because that is now illegal. From the 1st of May 2026, your tenancy rolls on indefinitely with no end date, and your landlord cannot change that fact under any circumstances. The only way a landlord can now end a tenancy is by proving a specific legal ground before a judge in a court of law. If your landlord tells you your tenancy is ended because your fixed term expired, they are factually wrong and potentially breaking the law right now. The third illegal thing your landlord cannot do is raise your rent more than once in any 12-month period under the new law. Before this law, some landlords were increasing rent aggressively multiple times per year as a tactic to force tenants out without formal eviction proceedings. That practice is now completely illegal, and any landlord who tries to raise your rent more than once per year is breaking the law. Your landlord must also give you at least 2 full months of written notice before any rent increase can legally take effect at all. And that notice must be given using a specific official legal document called a Section 13 notice, not a casual text or informal letter. If your landlord sends you an informal rent increase letter or text message without using the correct Section 13 notice, that increase is not valid. If you believe any rent increase is above the current market rate, you have the right to take it to an independent tribunal for review. That independent tribunal has the legal power to set what your rent should actually be, and your landlord cannot override the tribunal's decision at all. A landlord who raises rent more than once per year, or without proper notice, faces a civil penalty fine from the local council immediately. The fourth illegal thing your landlord cannot do is demand more than 1 single month of rent from you in advance before you move in. Before this law, landlords routinely demanded 3 months, 6 months, sometimes even more upfront before handing over keys to a new rental property. Under the Renters' Rights Act, the absolute maximum a landlord can demand or accept from you in advance is 1 single month of rent. This is now defined as a prohibited payment in law, meaning any landlord who demands or accepts more than 1 month faces serious financial penalties. And here is the part that surprises most people: even if you voluntarily offer more than 1 month advance, your landlord legally cannot accept it. The moment a landlord accepts more than 1 month's rent in advance, they have committed a prohibited payment offense under the Renters' Rights Act immediately. If a landlord has demanded excess advance rent from you recently, that is something you can formally report to your local council enforcement team right now. The council has the power to investigate, issue fines, and order the prohibited payment to be returned directly to you, the tenant, today. The fifth illegal thing your landlord cannot do is refuse your application or treat you unfavorably because you receive housing benefit or have children. The infamous no DSS ban that was plastered across rental advertisements for decades has now been completely and permanently abolished under the new law. Your landlord cannot reject your tenancy application on the basis that you receive housing benefit, universal credit, or any other form of government financial support. They cannot refuse you because you have children living with you. This is now clearly defined as illegal rental discrimination under the Renters' Rights Act. A landlord who rejects an application specifically because of benefit status or children is discriminating against you and faces penalties from the local council. This also extends beyond just rental advertisements into tenancy clauses, mortgage conditions, and even some insurance policies under the expanded scope of the new law. If you have been refused a rental property because of your benefit status or because you have children, you have grounds to make a formal complaint. Contact your local council or Citizens' Advice immediately if you believe a landlord has discriminated against you under these new rules, because you have rights now. Now, beyond the 5 main illegal things, there are several other serious violations that landlords are committing right now without fully realizing the legal consequences. A landlord who runs or participates in a rental bidding war is also now committing an illegal act under the Renters' Rights Act provisions. Landlords and agents must advertise a specific rent price, and they absolutely cannot accept any offers above that advertised price under any circumstances today. A landlord who advertises a property as price on application or as a price range instead of a specific figure is already breaking the law. Any landlord who had existing tenants before the 1st of May 2026 was also legally required to provide the official Renters' Rights Act information sheet. This information sheet had to be delivered to every named tenant by the 31st of May 2026, either digitally as a PDF or in print. A landlord who failed to provide this official information sheet faces a fine of up to £7,000 from the local council right now. And sending a link to the PDF by email or text is not valid. The actual PDF must be attached or delivered as a physical copy. Landlords who are found to have illegally harassed a tenant or carried out an illegal eviction now face fines of up to £40,000 immediately. The local council can now access a landlord's bank statements, financial records, email exchanges, and tenancy agreements as part of their expanded investigatory powers today. This means landlords can no longer hide their illegal behavior because councils now have the tools and legal authority to uncover it thoroughly and quickly. For the most serious and persistent violations, local councils can pursue criminal prosecution against landlords, which carries the possibility of an unlimited financial fine entirely. Rent repayment orders have also been significantly strengthened under the new law, meaning tenants can now reclaim rent paid during periods of illegal landlord behavior. The maximum penalty under a rent repayment order has been doubled, and repeat offending landlords are now required to pay back the full maximum amount always. Rent repayment orders have also been extended to cover superior landlords, meaning the entire property ownership chain can face financial liability for illegal rental practices. If your landlord has been doing any of these 5 illegal things since the 1st of May 2026, you have specific legal remedies available right now. First, if you have received a Section 21 notice after the 1st of May 2026, report it to your local council and contact Citizens' Advice today. Second, if your landlord told you to leave because your fixed term ended, know that this is wrong and you do not have to leave at all. Third, if your rent has been raised more than once in the last 12 months or without proper Section 13 notice, document it and seek advice immediately. Fourth, if your landlord demanded more than 1 month advance rent from you, recently report this as a prohibited payment to your local council today. Fifth, if you have been refused a rental property due to benefits or children, contact Citizens' Advice or your local council about a discrimination complaint today. For all of these situations, Shelter at Shelter.org, UK, and Citizens' Advice at citizensadvice.org, UK offer completely free guidance and support to help you take the right action. The Gov. UK website also contains the full official guidance on the Renters' Rights Act, including your rights and exactly how to report violations to the authorities. Every single landlord in England has been given clear official guidance about these new rules, and there is absolutely no excuse for non-compliance at all anymore. If a landlord claims they did not know about the Renters' Rights Act, that is not a legal defense and fines will still be issued accordingly. Share this video right now with every renter you know because most people are still completely unaware of these 5 illegal landlord actions happening around them. And if you know any landlords, share this video with them too because some landlords are genuinely breaking these rules without fully understanding the consequences they face. Every renter who watches this video and acts on this information is now significantly better protected than they were before they pressed play today. If you found this video helpful, please like it right now because it genuinely helps more renters find this critical legal information when they need it most. Subscribe to UK Housing Alert and hit the notification bell so you never miss an important update about housing law and your rights as a renter in England. We cover housing law, landlord rules, tenant rights, and benefit changes every single week in plain simple English, so you always know exactly where you stand. Your home is protected by law, your rights are real and enforceable, and no landlord in England can legally take them away from you ever again. A landlord who retaliates against you for reporting illegal behavior faces additional serious penalties under the enhanced enforcement powers now available to local councils today. Never be afraid to report your landlord because the law now firmly protects you from any form of retaliation for making a completely legitimate complaint right now. The new private rented sector database requires all landlords to register, and those who fail to register face civil penalties of up to £7,000 immediately. Some Section 8 possession grounds are only available to landlords who are properly registered on the private rented sector database, so registration is absolutely critical for compliance. A landlord who tries to evict using a ground they are not registered to use faces both a failed possession claim and a significant additional financial fine. The new Landlord Ombudsman service requires all private landlords to join, and those who refuse face fines of up to £7,000 from local councils. A landlord who ignores ombudsman decisions can be expelled from the scheme and then face further enforcement action from the local council directly on top of that. Renters who have experienced illegal landlord behavior in the past 12 months should check whether they are eligible to apply for a rent repayment order today. A rent repayment order could potentially recover thousands of pounds of rent you have already paid during periods when your landlord was actively breaking the law. The application process for a rent repayment order goes through a tribunal, and you do not need to pay a solicitor to make this application yourself. Citizens' Advice can help you understand whether you have grounds for a rent repayment order and can guide you through the entire process completely free of charge. If your landlord has breached decent home standards by failing to maintain the property adequately, you now have much stronger legal grounds to pursue them for compensation. If your landlord is advertising a rental price range rather than a specific figure, they are already breaking the new advertising rules under the Renters' Rights Act. Always check that your landlord has provided the official Renters' Rights Act information sheet, because failing to provide it carries a fine of £7,000. If your landlord uses a letting agent, the agent is also legally required to have provided the official information sheet, and both parties can be fined for non-compliance. Landlords cannot use tenancy agreement clauses to opt out of any of these 5 requirements because those clauses are automatically void under the Renters' Rights Act today. Even if you signed a tenancy agreement containing illegal clauses, those clauses have absolutely no legal standing and cannot be enforced against you by your landlord. The law is explicitly clear that no tenancy agreement can remove or reduce these rights regardless of how official or professionally drafted the agreement appears to be. Every single one of the 5 illegal things covered in this video applies equally to all tenancies, both new ones after May 2026 and older existing ones. There is no grace period and no phased implementation for these 5 key illegal actions. They all apply to every tenancy from the 1st of May 2026. A landlord who tells you these rules do not apply to your older tenancy because it started before May 2026 is completely wrong and misleading you deliberately. The rules apply to all assured and assured short-hold tenancies in England regardless of when they started as of the 1st of May 2026 without any exceptions. Keep records of everything your landlord does, including notices received, rent demands made, and any communications about leaving the property in case you need evidence later. Written records, screenshots, emails, and letters are all valuable evidence if you need to report your landlord or make a rent repayment order application in the future. The more evidence you have of illegal landlord behavior, the stronger your case will be when reporting to the council or applying for a rent repayment order today. If you know any landlords, share this video with them too, because some landlords are genuinely breaking these rules without fully understanding the serious consequences they face. Every renter watching this video is now significantly better protected with this knowledge than they were before they pressed play on this video today, so share it. UK Housing Alert is here every single week, making sure every renter in England knows their full legal rights and exactly how to enforce them effectively today. Remember that knowledge is your most powerful protection, so subscribe to UK Housing Alert now and share this video with every renter you know today.